Noong talakan kangen. Jadi assistant lady itu lagi cabut juga. Anything you buy from the Thank you. Kita dulu untuk pagi ini sudah rekod. Oke kok. Thank you.
야, 항어. cái 까나 볼까?
How's the connection? How did you information answer people number?
What are the benefits that we're going to get from E-sewa?
How many times will it take?
Okay. What about the next step? You can search from there.
Wi-Fi password.
Wi-Fi password.
Natin gitu, maya gitu, itu tuh, yang beri makan aku tuh orang itu. Ini sofa tuh.
I am Koshia Mao, the Additional Public Prosecutor of District and Session Court Senapati. We will be giving awareness on POCSO Act today to the public. Thank you, that's me, and with me there will be the women OC who will introduce herself.
Hi, I'm Sarah, Women Sub-Inspector, official in charge of Women Police Station. I'm here now with Madam Koshia to give the awareness on POCSO Act. Madam, would you kindly brief us about this POCSO Act 2012 and what are the offences covered under this Act?
Well, Sarah, I would like to tell you what is POCSO, because many people does not know the real abbreviation of POCSO. So POCSO is Protection of Children from Sexual Offences Act, which was passed in 2012. Now the main functions and the main purpose of enacting this act was that there are many harassment done to children, both male and female. So in POCSO, it is only offences which are committed for children below the age of 18 years. So 18 years means it will be both male and female. So offences committed against children who are below 18 years will be punishable under the POCSO Act 2012. In POCSO, it provides protection for all children from sexual offences, from sexual harassment, and then physical harassment. So under this act, there are offences which are defined under section 3, which is penetrative sexual assault. Then in section 5, it is aggravated penetrative sexual assault. Then in section 7, it is sexual assault. Then in section 9, it is aggravated sexual assault. Then in section 11, it is sexual harassment caused to a child. And then in section 13, it is also use of child for pornographic purposes. So there are different punishments for people who are committing this type of offences under this act. And then now in 2019, the act has been amended again and the punishments have been made more stringent. Why? Because the punishment which was given earlier in the first when it was first enacted, it was too less. The Parliament thought it too less because the offences which have been committed to children has been increasing day by day all over India also. And now, for example, I will just like to narrate about our district also. Even in Senapati district, we did not hear about this type of offences previously. But after 2018, 19, 20, up till now, we are here having cases which are more than 10. And as Sarah, you are also well aware that our Senapati PS is also handling so many POCSO cases now. And since the District and Session Court of Senapati covers Kampopi district also, we have come across so many POCSO cases. And I would also like to tell our people that once you approach the court, then it is very sure that in such type of offences which are committed to a child, then obviously the court will look into it and there will be obviously conviction for those children who are below 12 years. I would like to say that all punishments for POCSO offences, who has committed such type of offence, then there are various types of punishment. For penetrative sexual assault, before the amendment it was 7 years punishment maximum, but now it has increased up to 10 years. I'm sorry, I'm saying that 7 years is the minimum. Now after the enactment it is 10 years minimum. And then for those who have committed aggravated sexual assault, the minimum punishment is from 20 years up to life imprisonment, which means the natural life. Then in smaller punishment, when it was 3 years, now it has been enhanced to 5 years. So all the punishment under POCSO has been enhanced to make people aware that it will be scared for them to commit this type of offences in future, and they will know that we should take care of a child and not to harass our child.
Thank you, Madam, for the brief of the POCSO Act and all the offences that cover under the Act. And I found and feel that many of this kind of crime like penetrative sexual assault or sexual assault has already happened in our district also. And every year we registered, even in our station itself, we registered 3 to 4 cases. But I find degrading or decreasing. Last year and this year we got only 2 to 3 cases registered in our police station. So maybe people have started having aware of the act, or maybe people are not reporting the crime to the police station. This must be the 2 reasons why the crimes are not reported in the police station. So in this part, while reporting the crime to the police station, any person or any including the child who has the apprehension that an offence under this act is likely to be committed or has knowledge that such an offence has been committed, such information should provide to the Special Juvenile Justice Police, Special Juvenile Police Unit, or to the local police. Or every report of given under this such section shall be recorded in writing or be read over to the informant. And so this is the section given under reporting the crime deal under the section of 19(1) POCSO Act. And there is a punishment for failure to report a crime also. So whoever knows the crime that has already committed or who has the knowledge that it is going to commit, they should report to the police. Otherwise, if they were not reported the crime before the police, then there is a punishment for those who fail to report a crime. The punishment is 6 months and with fine. And those police officers or any who fail to report the crime, also there is punishment for those who fail to record the crime, also under section 21 POCSO Act. What are the cases that are reported before the police can be considered, madam?
Well, Sarah, I know that since you are the OC there will be lots of complaints which are coming before the station. So now what you have to consider is the complaint which is coming before you should be very genuine. Now, supposing if there is a complaint which states about a child being abused by a teacher, now we have to differentiate between that. You have to take the statement of the child and see what type of abuse was done, because there is a relationship of teacher and child also, parents and child also. And now what we have to differentiate is a good touch and a bad touch. That is very important, which you have to consider. Now, a good touch means a parent or a teacher just touching a child and caressing the child. That is a good touch. And just saying that, oh, my child, you have done well, or my student, you have done well. If it is just a touch like that, then you have to know that it is a good touch. And then for a bad touch is if someone touches a portion which is prohibited. For example, for a girl child, if they touch the private part, or if they touch a part where even the parents are also not allowed to touch, then in such a case, then you have to take it that this falls under POCSO Act, and you have to take immediate action and register that type of case. But there are many instances in POCSO also that sometimes even so many males are being victimized. We can cite an example. Once a child, now we are seeing that POCSO is below 18 years. But once you become 14, 15, 16, once you reach that age, then it shows that even the girl child has become an adolescent also. But then you have to take it that it is a POCSO Act, if it is done between that also. But for a child below 12 years of age, you have to take the statement of the child as correct. And then now there are so many rulings which states that only the statement of the child, even the sole testimony of the child, only from that statement, if it corroborates with the medical report, then a person who has committed an offense can be convicted. Now let me cite an example of a case which happened in our district itself. I think you were the IO in that case also. In that case, there was a complaint by a girl after she became pregnant for 6 months. Only after that the case was registered. So once this case was registered after she became pregnant, when she went for checkup, they came to know that she was pregnant. So the parents along with the child, they had complained. You have investigated the case very well, and it was charge sheeted and it came to the court for trial. During trial, what happened? The most important thing for the prosecutor is to see whether the investigation done by you was done, and then whether all the evidences placed before the court, it shows that all corroborated, and all the statements, all the witnesses which you have put up before the court, they all corroborate with one another, and the testimony of the child is the first importance. The second is the medical report. Now I will tell you why that case went on acquittal, because this child, she has given her statement, yes. Then the evidence, the personal evidence given by the mother and the father, what they had stated is that when the child was brought to the father, because the mother is the second wife, and then she came to the house of the husband when the victim child was only 1.5 years old. So in that case, the registering of the case, the commission of the offense, and the age which both the parents had testified before the court, it came above 18 years. So when the evidence of the parents were brought into consideration in the court, it only showed that she was already a major and not a minor. And then it was considered to be rape, and then under POCSO, he was acquitted. So this type of cases also happens. And then now one case is there, which is the first in district, and then in that case we got death sentence, and I think that case is still undergoing on appeal in the High Court. I think you must have heard about that case also. It happened in a village in Maram. So in that case, a 4-year-old child baby was molested and she was murdered. And it so happened that this case, the customary court had given a decision only giving a penalty of 50,000, and then the accused was banished for 5 years. But somehow this case came to the knowledge of the Mau police, and then they had taken up an sumoto case. After that, the case was registered and a fresh investigation started. And the investigation was done so well, and then the charge sheet came to the court, the trial was done, and then all the witnesses, they have stated that the child was molested, raped and murdered by the accused. So now this court had given conviction, and then that was the first death sentence which was in the record of Manipur also. And then as far as I am told, that was the first death sentence of POCSO Act. So if this such type of cases is reported before your station, then the court is there to give justice to the victim's family and to the child.
Thank you, ma'am. This is very much important, being the IO of the cases. While doing all the investigation part, we have to be very careful in collecting documents and in collecting the documents, like most importantly, the documents to prove the age of the girl is very important in the part of investigation, and also the examination report and the statement of the girl recorded under 161 CRPC, and moreover the victim child should be subjected before the magistrate for recording the statement under 164 CRPC, as it is admissible before the court, and it is admissible documents before the court, so that 164 CRPC should be subjected before the magistrate within no time, so that the statement of the victim is not tampered and it is properly recorded. And mostly POCSO is a neutral gender, and so the most victim that happened in Senapati, in our district itself, is mostly a victim girl, a girl child. So I heard that there are some few male child also become the victim of a POCSO act, but then so far I haven't come across that type of cases in our district. So there are some certain procedure that we need to follow while we are dealing with the child in conflict with law. So may I ask Madam, would you kindly brief us some of the child-friendly procedure while in investigation or in time of trial?
Well, Sarah, there is a very important question that you have asked me now. Now, child-friendly procedure. This is the most important procedure which even the police, as well as the public prosecutor, as well as the judge, which has to do the cases for child-friendly procedure. Now, the first thing that one should know is that the statement of the child, while you're recording the statement of the child, it should be recorded at the place of the residence of the child and not in the police station. I hope you are aware of that. And then when you are recording the statement of the child, then the police should not be in uniform. I think you are also aware of that also, because obviously a child will feel very insecure when someone is in uniform. So that point is to be very clear. And then the child must never come in contact with the accused again, because the trauma which the child had felt at the time of the commission of the crime, then when we come to the court for trial, then obviously the statement of the victim is to be recorded. Statement of the accused is also to be recorded under section 313. When the statement of the child is recorded in the court, then the court should assure that the child is never in contact with the accused. So, for example, when in the court, when the hearing is done, hearing of a child and of a POCSO act should be done in camera, not in the open court. The statement of the child should be taken in camera, which means it should be in a room where it is not a court, it is not a courtroom, so that the child will feel secure. And then another thing is that when the statement of the child is taken, then you have to assure that, the court has to assure that there is someone beside the child. Maybe the mother, if the child is feeling good, or if the child wants someone other than the mother, who she feels free with or he feels free with, then someone has to be beside her when the child is giving the statement. And then if the child is a child who does not understand Manipuri or English or Hindi other than the official languages, then there has to be a translator which is to be appointed by the court. And then the translator will have to translate the statement of the victim which is given also. Then now one should make sure that the identity of the child is not disclosed, which means the child's while publishing in media, the child's name should never be there. That is one thing. And there is an offense which says that if the child's name is published by any media or print or anything in writing, newspaper, then obviously those people is liable to be punished under the POCSO Act. Now, when we should know is that if the statement of the child is taken, then no aggressive question. It should be a simple language question. So even the judge, if he wants to question the child, it has to be simple. If the prosecutor is asking a question, then it has to be in simple language, and it should not be aggressive. We should not show that the child is being questioned very aggressively. This happens when the defense counsel is cross-examining. It usually happens. There are times that I have come across also. Some counsel, they start asking the child how the incident happened, and then why didn't you not shout when the incident was happening? This type of question I have come across, which I have strongly objected, and the judge used to tell the defense counsel not to ask such type of question. So in this time, even the judge has the right to ask the question of the defense counsel. After taking the question, then the judge will have to ask the child in a language very simple. So these are the things, child-friendly procedures. And then now in this procedure also, we cannot drag on these type of cases for so long. Evidence which you are doing, the investigation which you are doing, it is said that you have to complete it by 3 months. But at the earliest, it is better to complete the cases at the earliest. And in POCSO, it clearly states that even the trial of a POCSO act should be completed within a period of 3 months. So if the investigation, because dragging on the cases for long, we are showing that justice delayed is justice denied. There is a saying. So to do the trial at the earliest is giving justice to the family of the victim. A child should not be called repeatedly to testify. That is very important. Now, why a child is not to be called repeatedly is that because the child is narrating a story, not a good story, but a bad story which has hurt her. So we should see that the statement of the child is testified within the day of her examination. Sometimes the defense counsel asks for recall of the victim for cross-examining her again. But in the act itself, it says very clear that a child should not be called very repeatedly to testify. So this is one very important point which I want to say. And then, as I've already stated a little bit also, it is the judge who can intervene if there are questions which are aggressive. And if those which are not admissible, then it is the judge to intervene and stop the defense counsel also. Now, when a child comes to the court for giving her statement, it should be in a child-friendly room where the child feels free with someone. Now, in our court also, what we used to do is a child below 12 years, we used to buy doll, then we used to buy eatables, and we used to buy all these things, all these things, and keep it in the room where she's there. And then I think you have also known about that also, because when a child is given all these toys and all, then the child feels very free, and then she will not feel that she's in the court also. So that is also one very important point of child-friendly procedure during trial and during investigation. And then while investigation also, I think you are also doing that in your station. You're not supposed to do in the station, but then when you're examining her in the place of her residence also, it is very important that you give her something where you feel that she's not giving a statement before you.
While dealing with the POCSO crimes, it is very much important following the child-friendly procedures, even in investigation or at the time of trial. So thank you, madam. This is very much important that we need to have all this kind of knowledge. And in the part of investigation, identifying the accused person and arresting the person is also a very important part of the case. So therefore, while arresting the accused person under section 41, the accused can be a male or female, or it can be an adult, or it can be a juvenile. So in the part of arresting the adult, police usually arrest the person under 41 E-CRPC. And so while arresting the person, the officer who arrests the person should have accurate or visible or clear identification of his name, which facilitates easy identification, and prepare the IO of the case should prepare arrest memo at the time, and that should be attested by the arrestee or a member of their family, and also it should be there should be a witness signed in the arrest memo, and countersign should be done by the arrested person. That is, the IO also should be should countersign in the arrest memo. So, but while arresting a juvenile in conflict with law, maybe there are some other rules to be followed. So, madam, would you kindly brief us like which are the procedure to follow while arresting the juvenile in conflict with law?
Well, Sarah, again, that is also one very important thing which everyone should be aware of. Now, as you have said very clearly that arresting an adult, you have to comply with the CRPC. But when a child becomes an accused, then it is said as juvenile in conflict with law. So when you are in conflict with law of a child, then you're not supposed to use the word arrest, but you have to apprehend. You have to apprehend the juvenile in conflict with law, and then he or she has to be kept in a juvenile home or in an observation home and not in the police station. And many a times it happens also that parents, they used to come and ask for the child, for the custody of the child, to take back the child who are in conflict with law. So then there is a form, a bond which has to be signed before the OC, and it has to be done. And if the parents can guarantee that the child will not, the juvenile in conflict with law will not abscond, then obviously I think we have come across so many cases where parents have been given the custody of the child in conflict with law also. And then you have to produce the child in conflict with law not before the POCSO court, but before the JJB. Before the JJB, because the child is a juvenile below 18 years. So it is the JJB who is to decide of such cases when both the child, both the victim and the accused, it becomes a minor. Then such type of cases are to be tried before the JJB and not before the POCSO court.
Okay, madam, to bring the case into a justiciable conclusion, investigation is the most important part. The investigation is a systematic process to find out the facts, include searching, examination of witnesses, arrest and interrogation of accused person, seizure of incriminating substances of crime, modus operandi of accused person, preservation of forensic evidences and collection of convincing evidences. It is the process of collection of evidences that what the crime is committed, identifying the accused person and providing credible evidence before the court. So seeing justice to the victim and giving fair trial to the accused is the main point that the police are doing, or police are struggling for. That is what I want to see on the part of police.
Well, Sarah, you have talked about the investigation part very well, and I should applaud you also, because I think you are being awarded the best women police in 2022 for the state of Manipur women police also. And then now I will just like to share with our public and also to you that there are certain issues and challenges also which the court is also facing, the police are also facing, and even during trial also the court also faces. So now the main duty of a prosecutor is to conduct the cases which are being put up by the investigation and to see that all the evidences which the investigation has collected, they corroborate with one another, and all the material evidences along with the physical evidences of all the prosecution witnesses who come before the court and they testify along with all the material objects, with all the exhibits that the investigation has put up, if it corroborates with each other and it has to be proof beyond reasonable doubt. The court has to ensure and see that the case has been proved beyond reasonable doubt. If that is the case, then obviously all cases can be convicted. So the main issue which we usually face is that in hill districts, it is very hard because many a times the customary court, as I've stated about one case now about that Maram village case, it was decided by the customary court. Now sumoto we have taken it up. Now in many cases also it is not reported also. It is out of 100% I can say that only 5% is reported. Many crimes are being committed in the family itself, then among the relatives, near relatives, and then even in the office and all, even in the schools and all, we have come across a principal committing an offense of POCSO also. So this type of cases is happening, but many a times a parents or a teacher or someone to whom the complaint is reported is not reported before the investigation, before the police. And we very well know that in such cases, Section 21, as you have also already said, for not reporting to the police, this one the public has to be very much aware, because everyone has a bounden duty to take care of a child who are growing up day by day, who will become the citizens, who will become pillars of the nation tomorrow. So if they are not taken care, then it is the fault of the family, it is the fault of the society, and it is the fault of the court also if justice is not given to any child where POCSO cases happen to the child also. Now, there are certain general principles of the POCSO Act also. So this type of general principles, what are the general principles? Just for example, it is a right to life and security. Right to life and security should be given to the child also. And then we should see that the best interest of the child is given. The interest of the child should be taken into consideration in the general principles also. And then the right of a child is that the child should be treated with dignity and compassion. We should not disregard a child who has given such complaint, and we should not think it otherwise that the child must be giving a false complaint. Obviously, a child will all say the truth. As we have already discussed also, a child will never lie about she or he being abused by a male or a female, because it happens that even an accused happens to be a female also. Yes, in our district so far we haven't come across such cases. So, and then there is a right not to be discriminated. We should see that those victims, those child who comes across such offences, then they should not be discriminated. They should be brought together to the, even in the school, then even in the place where she has taken her testimony. We should see that she is not discriminated by anyone. She is treated equally like the rest of the other children who has not come across such thing. Now, I will also like to give an awareness to the public that in POCSO cases, we have the victim compensation scheme. Victim compensation scheme is usually given at the end of the trial when the conviction is given. During the sentence, the judge announces the award of how much will be the compensation amount. But there is an interim compensation also at the time of the initial registration of FIR. If there is a complaint of the child being abused or sexually harassed very badly or been raped very badly, then in such cases interim compensation can be asked either by the parents or even the IO can write up before the special court, which is there in POCSO Act also very clear, to give interim compensation under section 38 of the POCSO Act. It is very clear, and it depends the interim compensation as well as the compensation which is to be given at the end of the trial also. It will depend on the gravity of the offences committed to the child. Supposing if a child is being raped, then the compensation amount is 5 to 7 lakhs. If she is being injured, then it will come from 50,000 to 2 lakhs. It all depends on the gravity of the offences. And if a child is raped and murdered, then the maximum compensation which is given is 10 lakhs, which has been given. And this time, in regarding the Maram case, the highest compensation amount was given. That was an amount of 27.5 lakhs was awarded to the victim's family because they had lost a child only at the age of 4 years old. So these are some cases which I am citing and which we are discussing, so that public will be aware that for not reporting there is an offense, there is a punishment. It is an offense, because usually in the society, if I report about my child's abuse, then it will be a bad image for our family. That is one thing. We only think of our image. We do not think of the child's safety and the child's security. So I will urge everyone not to think of ourselves first, but to think of the child, because it is the child whose mental trauma will be there till his or her term of life. We should see that she is rehabilitated properly, she's been taken care of properly, and that such type of child should be made to feel that there is a law which protects me, and then she will be able to live up to the expectation of the parents or the society or the community again. So the importance of POCSO Act, we have to make each and every household know that this POCSO Act is a very good act, and even though the punishment is very stringent, why? Because the child is to be protected and the child is to be saved from such type of people who behave like animal, not as human being. They should be made known that such type of person who commits such type of offenses, there is a society, and then they should not be allowed to live just like animals in the, what to say, in the society as well as in the state or in the country, wherever they may be. They should be made to know that. And then, for example, I will say that I will also like to share that we have come across one case where the accused absconded after committing rape of a 14-year-old child. I think you must be remembering how much difficulty you came across while investigating that case. The accused had absconded, and it was more than 1 year that we were not able to get the accused. But somehow everyone should know, and we must have all heard about a song also, that you cannot escape the long arms of the law. I think you've heard about that song also. So the arms of the law is very long that you will not be able to hide. Even if you commit a crime in Manipur and you go to US, one day or the other you're sure to be arrested. Even if you hide somewhere where you think that people will not know or people will not see you. Obviously, if there is a case, then one day or the other you are going to face the consequences. So now, as we come to the end of our conversation, thank you so much. We have had a very good time, and then I think people have also got some rough idea of what is a POCSO Act, what is the importance of POCSO Act, and how the victim is compensated for the offense or for the crime committed to him or her. So these are the basic, we are just going to the basic only, we are not going to the interior of the sections also, because since we are giving a public awareness, I think both of us have just given some insight about the importance of POCSO Act. Thank you.